Hello everyone, this is Anushka Vora. In this session, I'll be talking about policy on materiality of RPTs. The general dictionary meaning of the term policy means a plan of action that has been agreed upon. In the context of RPTs, the policy on materiality of RPTs is a document laying down the procedures governing the RPTs, the determination of materiality, the entire process of approval, reporting, and disclosures. The requirement of policy comes from Regulation 23 of LODR. Under the listing agreement, clause 49 also provided for preparing policy on RPTs and making it a part of the annual report and disclosing the same on the website. So today we'll study about the contents of the RPT policy, what all should be the contents and what all should be included in the policy. So I'll share my screen and we'll start with the same. Okay. So these are the major contents of the policy. Starting with the preamble. Preamble lays down the objectives of the policy. What all the policy is going to cover in itself. What will be the objectives of the policy? For example, determination of materiality, identification of related parties. That is the preamble part. Definitions, the major, all the definitions that cover the RPT framework, those come under the definition clauses. Under this, there has been an addition that is of material modification. Material modification, when we see, I'll just share the definition of material modification that has been come by way of this amendment under LODR. So material modification has been defined to be a certain limit which is at the discretion of the audit committee to decide. And in case of material modifications, prior approval of the audit committee will be required. So it's written here that the audit committee of the listed entity shall define material modifications and disclose it as a part of its policy. So disclosure in the policy is required on material modification. So this definition of material modification will be laid down by the audit committee, will be approved by the audit committee, and will form part of this policy. All right. So moving on to the next part, which is identification of related parties and related party transactions. Now, okay, we have laid down the approval process on how to go about in case there is an RPT. But firstly, the company needs to identify whether a particular transaction is considered to be RPT or not. That is that transaction with a related party? So for that, the companies, they maintain a list of related parties. The directors, they disclose their interest in form MVP1 in the beginning of the at the beginning of every financial year and whenever there's any change. So sometimes there's a possibility that a director might not be aware about disclosing his interest in case of any change. In that case, the companies need to familiarize the directors about the same. So this list of related parties, it should not be that historically one list is prepared and everything is going on according to that. There should be a periodicity within which the list should be reviewed and updated. And this is more so because of this amendment that has come and which is which has widened the definition of related parties. So like as I mentioned, the companies need to maintain a list of related parties and they need to review and update it on a periodic basis. Then one more requirement which has come by the way of amendments and that now the companies are also required to prepare and keep a list of related party of their subsidiaries as well. Now from where this requirement comes from? With the amendments that have come under the regulation 23, if in case I'm a holding company, I have an unlisted subsidiary, unlisted subsidiary to which regulation 23 is not applicable. In that case, all not all the RPTs, but a certain threshold limit that has been specified, which is 10%, which is 10% of the annual consolidated turnover of the listed entity. And from April 23, it is 10% of the annual standalone turnover of that unlisted subsidiary. So if this 10% limit is crossed, now if the unlisted subsidiary enters into any transaction which exceeds this limit of 10%, in that case, it will go for approval process at the holding company. At the holding company, the audit committee's approval will be required. So now I also have to maintain the list of related parties of the subsidiary as well. And that also needs to be reviewed and updated on a periodic basis. Okay. Next, we move on to the approval framework. Now, when we talk about approval framework, there are three approving authorities in the RPTs: the audit committee, the board, and the shareholders. Now, when we talk about audit committee, there are two kinds of approvals that the audit committee can provide, which is, one is the omnibus approval, the other is the specific approval. Now, omnibus approval is for transactions that are in the ordinary course of business and are repetitive in nature. Transactions which are on recurring basis. For that, I can obtain an omnibus approval at the beginning of the financial year, or preferably at the end of the financial year for all the subsequent, for the transactions that I'm going to enter in the following year. All right. So for that, I can obtain an omnibus approval that is valid for a particular, for one financial year. For transactions which do not qualify to be taken for omnibus approval, I will have to go for specific approval of the audit committee. That is, I'll have to take approval of the prior approval of the audit committee. Now, if that next, I will have to identify whether the transaction which I'm entering into is that on an arm's length basis and in the ordinary course of business. If it's not on arm's length basis or not on ordinary course of business, I will have to take approval of the board as well. Now, one point here is that under LODR, there's no reference of the board. LODR does not talk about arm's length or ordinary course. These two terms have been laid down under Companies Act, and there it mandates for board. Next is shareholders approval. Next, I will have to see whether my RPT breaches the limit of materiality that has been laid down under Section 188 and under Regulation 23. For that, I will have to go to shareholders for approval. Now, another term for which I'll have to go for shareholders is material modification of an RPT that has been recognized as material under Regulation 23. Which means that in case of material modifications of all RPT, I'll have to go to audit committee for prior approval. Material modification of material RPT, I'll have to go to shareholders, prior shareholders approval. Here the approval is prior. Prior approval of the shareholders. Now, question which arises here is that sometimes due to urgency of a particular transaction, it might not be possible to call an audit committee meeting or to call a board meeting and take approval for RPT. So in that case, can the same be passed through RBC? Now, when we talk about RBC, that is resolution by circulation, we talk about, under law, we talk about Section 179, SS1. Section 179, which deals with the powers of the board. 179 has a list of items which says that for approval of these items, that the approval can be taken only at the board meeting, which is that for these items, RBC cannot be. Under SS1, there is an illustrative list of transactions which states that for these particular transactions, I'll have to take, I'll have to do that in the meeting itself and not through apps. Now, for here, for RPT, it has been mentioned that if it is not an arm's length basis, I cannot do it through apps. So under SS1 only this has been laid down with reference to RPTs. So, which comes to that question that if it is on arm's length, can I do it through RBC because there is no restriction. While there is no restriction, but looking at the intent of taking things at the meeting and not through RBCs, is that items which require detailed deliberations at the board or the committee levels should always be taken at the meeting. Where discussions are required should always be taken at the meeting and should not be passed through resolution by circulation. Well, for RPTs, what one interprets is that it would require discussion. The RPTs which I'm entering into, it has to be in the best interest of the company. So ideally, they should be taken at the meeting, but if the transactions are very urgent and since prior approval is required, RBC can be seen as an option but should be taken as a last resort. When there's no way to conduct board meetings, the same can be taken through RBC. Okay. One more question which is relevant here is that in case no approval has been taken, which means that I have not taken transactions through the board meeting or the audit committee meeting, and I have not even passed the same through resolution by circulation. Which means I have not obtained prior approval of the audit committee and I have done the transaction. The terms of the transaction have been freezed. In that case, can ratification happen? Can those transactions which I've already entered into without obtaining the prior approval of audit committee, can those be ratified? Can those be regularized in any circumstance? So for this, we see section 177, which talks about ratification. It states that in case of any transaction involving an amount not exceeding 1 CR is entered into by a director or officer without obtaining the approval of audit committee, and if it is not ratified by audit committee within 3 months from the day of transaction, such transaction shall be void. So what one needs to understand is for RPTs is the prerogative of the audit committee. In case no approval has been taken due to maybe non-identification of any related party or lack of systems in the policy to identify that a particular transaction is an RPT, then it has to be ratified. It should be ratified at the immediate next audit committee meeting, and then it is at the discretion of the audit committee to decide whether to ratify, that is regularize the transaction, terminate or revise the terms. So it's the discretion of the audit committee. The audit committee has major role to play in this case. So although the situation should not arise where approval has not been taken, the company should, as I mentioned earlier, that list should be maintained and that should be updated periodically, and whenever any particular transaction comes, all identification criteria should be laid down to identify whether it is with a related party or not, so that all those approval requirements does not get skipped on the part of the company. Because in case of ratification also, if it is ratified, appropriate disclosures have to be made. That is disclosures under the regulation 23 subregulation 9, where half-yearly disclosure of RPT is given. Under the corporate governance report under regulation 27, where we report on the material RPTs that have been entered. And also the affirmation, the annual affirmation, which is given that all that prior approval was obtained for all RPTs, prior approval of the audit committee. And in the financials are the notes to accounts. Moving on, we talk about exemption and report. Now, there are two kinds of exemptions, statutory and non-statutory. Statutory exemptions, that is the exemptions that have been laid down under the Companies Act and under LODR. Okay, so LODR and Companies Act both had provided that approval will not be required in case RPTs are between two government companies, between holding and its wholly owned subsidiary whose accounts are consolidated. Under LODR, one more addition has been there, which is RPTs between two wholly owned subsidiaries whose accounts are consolidated at the whole level. Between these two wholly owned subsidiaries, no approval is required. And in the LODR, other exemptions have also been laid down, which is preferential issue, corporate actions where dividend is being paid, actions which do not which place all the shareholders at the same level, and there's no option of preferring one, and there's no burden on one and benefit on the other. So those exemptions have been provided in the LODR. Now, other than the statutory exemptions, many of the companies, they also provide for non-statute exemptions, mainly which, some examples of that are managerial remuneration, CSR reimbursement. Something which, which is on a recurring basis, that they form it as an exemption and disclose it in the policy. One important thing here to understand is that while managerial remuneration, CSR, things like that are recurring in nature, and managerial remuneration is again the role of the NRC. For CSR, it's the CSR committee. But when we say that it's within CSR is done through a related party, or managerial remuneration is given to a related party, in that case, the role of the audit committee comes first. The NRC and the CSR committee, they would analyze the viability of these transactions with respect to their role that has been laid out. But audit committee's role with respect to RPTs is entirely different. So the points of analyzing are different at the audit committee level, at the NRC and CSR level. So while this can be provided as an exemption, but the audit committee's approval can be obtained for the same, for exempting it. Or one has to understand that the role of the audit committee and these two committees are indirect. When we talk about reimbursements, transactions which are purely of reimbursement nature, which is they are not benefiting any party, and there's no burden on another party, these can safely be exempted under the policy and no approval. So for policy carve-outs, we have done research of top 100 listed entities where we have found out what all these entities exempt as a part of their RPT policy. Where we find, this reimbursements, remuneration, CSR, dividend, which has now been exempt. Okay. So what all other contents? So we have talked about exemptions under the policy. Effective transactions not previously approved has also been discussed. Now, reporting of RPTs is already discussed in the ratification part. The RPTs, there's half-yearly disclosure under Regulation 23, Sub-Regulation 9. There's quarterly disclosure under Regulation 27 in the corporate governance report. Then there's Form AOC 2, where I will have to report transactions which were material and which were not in the ordinary course, and in the financials as notes to accounts. Then we talk about review of RPT. Review of RPT is that the audit committee should review the RPTs that have been entered into on a quarterly basis. For a particular quarter, the RPTs that have been entered into, the audit committee should, in the next meeting after the end of the quarter, should review those transactions. This policy, the policy on materiality of RPTs, has also to be reviewed once every 3 years by the board, that has been mentioned in Regulation 23 itself. Now, one more important thing here is that there should be a clause in the RPT policy which automatically subsumes any amendment that comes in. That is, it provides that any amendment which comes in the law or regulation would automatically be deemed to be adopted in this policy. So that was it on policy on material RPTs. In case of any queries, we can put the same on the comment box and we'll resolve the same. Thank you very much.